A Trump-appointed judge just ruled that the president acted illegally by invoking the Alien Enemies Act to deport Venezuelan migrants. Right, and this coming after federal judges in D.C., New York, and Colorado have already issued temporary restraining orders blocking the White House's use of the more than 200-year-old act. But then the Supreme Court got involved, telling the administration to go ahead, but at least give detainees a chance to challenge their removal, and later issuing an unusual middle-of-the-night order to halt another round of deportations to El Salvador that lawyers claim defied the court's earlier direction. But now, after all that chaos, this is the reportedly first decision permanently rejecting the administration's legal justifications for using the act. Because the law, it does give the president broad power during an invasion or predatory incursion, including the authority to deport subjects of the hostile nation or government. And so in March, you had Trump signing a proclamation invoking the power to send more than 130 immigrants to a notoriously brutal Salvadoran mega prison with little to no due process. But specifically, we saw in his ruling this week, Judge Fernando Rodriguez Jr. saying that the historical record renders clear that Trump's invocation of the act is contrary to the plain, ordinary meaning of the statute's terms, and adding that a state of invasion does not exist just because an official has uttered certain magic words. Now that said, the ruling of course does not stop the government from deporting someone under regular immigration laws, and notably it also only applies to migrants detained in southeastern Texas, but you do have people like the director of Columbia Law School's Immigrants' Rights Clinic saying that while this decision may not be binding on other federal courts, it is extremely detailed, well-reasoned, well-grounded in the law, and hopefully other federal courts will consider it precedent. Though this is on the flip side, you have the DHS spokesperson saying in a statement that the administration expected a higher court to quickly vindicate our position. So obviously not the end of this saga, so follow to stay in the loop.